Calling all beings. Calling all beings.
Hey, good evening, everybody. Welcome back to Calling All Beings. I'm your host, DJ, and this is the most special night we've had in quite some time because we have an esteemed panel of legal excellence here and a great legal researcher who has just showed up to make my night complete. So we're going to get right into it. But before we get into that, we're going to introduce a Massachusetts answer to Helen of Troy. She is, of course, the cab collaborator, my home girl, Bea. What's up, Bea?
Hi, how are you? Hi, everyone.
How you doing?
Good, good. Happy Monday.
Yeah, happy
We got the
Monday.
right date. We got the right time. So everything's good.
You fired up? We ready to do this thing?
Yes, let's do it.
We gonna do the damn thing. We got some real badass lawyers, legal minds here. And we got Olivia, a legal researcher here who has blown everybody's mind. You know, she's the one I said at the meal of food she could sign my face with a Sharpie if she came. And I mean that. I really do. So, all right, without further ado, so let's start with this young lady right here, since she's sitting right next to you. And she has taken the Karen Reed legal universe by storm, appearing on shows, just doing a fantastic job, laying it down, giving her legal opinion. She's extremely passionate about the case. That much is clear. And we're just blessed to have another lawyer in the community, along with our second guest, the first gentleman to sign on to this roundtable. And so without further ado, let's introduce the homegirl. She ain't playing no games with you. Know what she's doing. Give it up for man Gallagher.
Hey, everybody.
Can I get it, man? For Nan Gallagher. Hi, Nan.
God. Hi, how are you? It's so great to be here, guys. I'm very excited. And, I guess I maybe took the Karen Reed movement by storm, but I'm like late to the public game. And I feel
That's
like
okay.
I can learn so
We
much
love
from
it.
everybody else.
Yeah, we love
Thanks
it.
for
Yeah,
having me.
and you're teaching us a lot as well. So let's bring on your brother counsel. This gentleman practices law in Michigan. He has been breaking it down. And Bea was just talking about how fantastic he is and how succinct he is in his breakdowns. And I've been an admirer of his. I've been following him for quite some time. People were asking, he's got to get on with Mark Betterow and so forth. So we tried to put that together. Mark had other things going. And thank goodness Nan agreed to, well, she was going to be invited anyway, but then Mark couldn't come. So we had her and Olivia come to the rescue. So without further ado, let's introduce this gentleman. He is my Jewish brother. Put your hands together for my man, Brother Counsel.
Yay.
That is quite an entrance. I usually don't get that type of.
Yes, sir.
You need to come back more often. We'll give you
Yeah,
all
I
the
know. I mean,
flowers.
I've been on a lot of shows. I've never gotten an entrance and applause like that. So you got a great crowd tonight.
I will come in court and do this I will do this right in court when you make your entrance. You know what I mean?
That would be really nice. I would put the extra, jump in my step as I'm going to the argue my motion or case, whatever it is.
I agree with that. I think us lawyers would really love a fan base when we're coming into court.
We'll
Usually we don't get
do it
that.
for Nan Gallagher also. No doubt about it, man. No question. So, all right. This young lady, I guess Brother Counsel is not familiar with her. Nan Gallagher is familiar with her because she has become a confidant, friend, and researcher for Melanie Little's channel. She has also helped me out and rescued me a couple of times. Literally, we have done shows where we read her very extensive tweets and analysis on air, but I'll use a different accent each time. It might be Irish, it might be Scottish, it might be Northern England, it might be London. So yeah, you never know what kind of accent. Oh, I love doing the John F. Kennedy, the Hyannisport accent. I'll do that one as well. So let's introduce her. It is an honor to have you on the show. So party people, put your hands together for Olivia Lambo. Oh,
Hi, everybody.
Hi, Olivia.
what is up? Where's my applause track? Give it up for Olivia. Thank you, ma'am. We appreciate you.
By the way, Brother Counsel, I think you follow me on Twitter, but maybe it's because my name on YouTube is usually Olivia Nile, so that might be why you didn't recognize me.
No, I
Initially,
definitely recognize you as on Twitter, and I do follow you, and I get some of the court filings and things like that. But I don't think I think seen you or heard you on a podcast. So that's all I meant.
Oh yeah, no, it's great to be here with everybody. I mean, I'm a huge fan of everybody's work here, and I've actually been watching your work, Brother Counsel, since before you started your coverage on this case. I love your work on the Adelson, Dan Markel case, and I think you also did Michelle Troconis, if I'm not mistaken.
I did.
Yeah,
Michelle Troconis was a
that was
a long
interesting
trial. That
one.
was very tedious. Yeah, that was a hard trial to cover because there was also a lot of boring days. You know, with Karen Reed's case, there wasn't so many boring days. You know, like there was always something going on that day in court that was exciting to talk about. But there was a lot of like DNA evidence in Michelle Troconis case. Some of it was really tedious and difficult to just recap and make exciting.
Things like
Karen
chains of custody and forensics, right?
Yeah, I mean it's just it's unbelievable, this case. I mean, the Karen Reed's case, there's nothing like this case. I mean, it's just unbelievable. I mean, I've been covering a lot of cases, and a lot of cases that I'm passionate about, like the Adelsons, Ashley Benefield. I was very passionate about Michelle Troconis. I mean, there's a lot of cases that are very interesting that I have a lot to say on, but there's just nothing like the Karen Reed case. It's just unbelievable. It's just.
Yeah, I think you were saying in a recent video, unprecedented.
Yeah, exactly. Unprecedented. I mean it. I mean, like, today was a busy day for me. I mean, I don't get so busy, but today was just it was a very big. I mean, from the morning and from my work, it was just one of those days where I didn't stop, and I'm not even sure what's going through my mind now. So I think I should probably just be quiet and listen to the other attorneys on this panel and just nod, in agreement.
You know what? This, by the way, just so you guys know, everybody in the chat, I want to welcome everybody. Like you're all saying, it is an amazing panel. We got to get right into it because Martin has a hard out at 5:15. Brother Counsel, at 8:15 your time. I'm in Colorado time, so forgive me. So we kind of want to get it going so that all three of our esteemed panel can get their takes in, and then we can just get to open discussion where they can discuss whatever they like. I know that Olivia has a mountain full of different topics to get to after you guys get to your initial one. If you are wondering why I'm wearing yarmulke, I am in fact Jewish. Even though I have an Italian last name, an Italian father, I'm Jewish. So I know my mother's proud of me, and I got authorization from Brother Counsel to wear this today. So rock on,
awesome.
brother. So, yes, it's been a while. So
well, you don't need my authorization, DJ. You can do whatever you want.
Well, people thought, that maybe you'd be, because I don't normally wear one, but I was going to ask Mark to wear one too if he was here because he's Jewish also.
Oh, really?
But oh yeah, I was going to try to do all three of us. But anyway, thank you very much for your endorsement. Like I said, my mother's, she's up there, but I know she's proud of me today.
Okay.
So
we're all proud of you.
So why don't we get started with, let's go ladies first. Why don't we get started with Nan, and then we'll go to Brother Counsel Martin, and then we'll go to Olivia. So Nan, would you like to present your topic to the roundtable, ma'am?
Yes, I have a question first, DJ, which is just
Yes,
because this is my first time being on your show, and I've seen some. And I'm now I'm subscribing and following, and I've been
Namaste.
I don't know how I've been able to see as many streams as I've been seeing and now hopping into them. Because so definitely want just a tip from you, which is
Yes,
how in depth do you want me to go with a topic? I know you were talking about have a hypothesis, and I've been having things run through my head.
Yeah, so essentially what we do, hello, please, Pastor Pepper. Thank you so much, love. I appreciate you. So essentially you're presenting something you want to get their opinion on.
Yeah.
So you can truncate that as much as you like. and be succinct. There's only 3 of you. I've done roundtables with 9 people, and it can take a long time to get through them all. But I think we're going to be okay. But go ahead and present it and get your colleagues to take a look.
Great. So actually, what I'd really like to know from Olivia and from, I'm going to call you Martin, because even though you are my brother, a fellow counsel. And I happen to love the name Martin. So this is a kind of specific issue, and it popped up yesterday when I was on another stream, and I really wanted to get your take on it. So now that we know that the Commonwealth has presumably a new accident reconstructionist who's, I think some inferences might be able to be drawn that he or she, and I don't recall but if they identified the name in their production, their voluminous production, but let's assume he's a he for now. And the presumption is that he's being presented to button up the accident reconstruction piece of the Karen Reed prosecution and to clean up the performance of Trooper Joseph Paul. Assuming that's the case and that new accident reconstructionist comes in, I wanted to get both of your takes on whether or not you feel he is going to be relying upon Trooper Paul's findings, discarding them, offering new opinions, offering opinions that adopt some of his, meaning Trooper Paul's, and new ones, because it really got me thinking when I was talking on another stream about how much of Trooper Paul's findings come into evidence due to hearsay reasons and other evidentiary rules. And then I also thought, I was watching a more mainstream media covering this particular issue, and that mainstream media, which I have to get in here, DJ, is completely lackluster compared to all of the content creators. Like if people want to know how it really is, they got to follow the content creators. But that mainstream media outfit, which I do try to keep tabs on to see what's being filtered to the public, they were kind of saying this was a calculated effort on the part of the Commonwealth. They made a decision here to probably abandon Trooper Paul and start fresh and possibly face, which I think they will, scrutiny from Karen's defense team by, hey, well, what about this other trooper who showed up and was there pretty early on and taking measurements and drawing his assertions? I'm just trying to get your take on what do you think the Commonwealth's anticipated strategy will be with that?
Ladies first.
Thank you. Well, it's a good question, and I think it's a unique dilemma to this case because it appears that the Commonwealth, I think to quote Hank Brennan, is retooling its entire case, and it looks like they have gone out and hired a handful of new experts, beyond just the accident reconstructionist.
Yeah.
And I don't recall if the accident reconstructionist that they've hired, if that's the same person as the Shannon Burgess, the
Bits and bytes guy.
Yeah, the chips guy. I think it's different, but
yeah.
In any event, I mean, it really depends on, is the defense going to call Trooper Paul? Because, presumably the Commonwealth isn't going to call Trooper Paul if they have a new accident reconstructionist. So, I guess the most direct way to kind of impeach the new accident reconstructionist via Trooper Paul is by the defense calling them in their case, which, has certain limitations because they can't cross-examine him. But I don't think that will be that encumbering to this defense team. But I don't know. I mean, it's like, then there's also the other issues of how long is this case going to be? I mean, personally, I don't believe the defense should cut its case at all. I think that was probably something they probably regret from the first trial, is cutting down their case so much.
Right.
Because if you recall, they had an extensive witness list, and they had a lot of witnesses on their witness list that were not on the Commonwealth's witness list that they ultimately didn't end up calling. I think because things were at that point taking so long and they were trying their best to read the jury and whatnot. So yeah, I mean, I don't know. I'd be curious to hear Brother Counsel's thoughts on if the defense were to call, if he thinks that's a strategic move for the defense to call Trooper Paul in their case in chief, or how you think they might handle that.
He's so cruel. So cruel. Sorry.
My thoughts are that I think if I was the Commonwealth, if I was Hank Brennan, I would stay as far away from Trooper Paul as I possibly can. And that would mean, if at all possible, in my case, not call him. And that would mean that in terms of the acts and reconstruction, so he's got some expert. I think someone's been posting his card around Twitter, and it is a he, I believe. And I mean, this is what reports are anyway. The real question that I have about this action reconstructionist is really, what's he going to say? I'm so curious as to what he's going to say and how he's going to contradict the ARCA experts. And as I've explained in other shows, I don't think a contradiction is enough. If you're the Commonwealth and you've got to prove your case beyond a reasonable doubt, and these two ARCA experts, for me, at least as a lawyer sitting here, these are the ones that just absolutely was the nail in the coffin for me, why there's absolutely reasonable doubt here. If this biomechanical engineer does not absolutely wipe the floor with these guys, the Commonwealth is going to be stuck with an expert versus experts, and they've got two. Again, I don't know how many experts the Commonwealth has, but these ARCA experts are extremely qualified. They're extremely impressive. And the only way that you're going to be able to prove your case beyond a reasonable doubt is if your expert can absolutely destroy these guys, which is probably, as Dr. Rentler said, very hard to do. That's just what I'm wondering. I really wonder what his testimony is and how exactly he's going to explain how this interaction could have happened and these injuries resulted. So I think that's going to be the most interesting part of the trial for me. Because I'm an experts guy, and that was what did it for me. In terms of Trooper Paul, if I was the defense, I don't think I would call Trooper Paul just to completely embarrass him on the stand. I don't know if that really helps my case as the defense. Just to embarrass him and show he's an idiot. There's probably a lot of there's a lot of policemen that you can probably just call to make them look stupid, but you got to win your case. And here the way that Karen Reed wins her case is just having Dr. Mee Russell, having Dr. Richard Green, having these experts testify, and that'll win that'll carry the day. And I got Brian Higgins on the phone at 1:34 in the morning. It's it just, the more that you uncover in this case, the more that you're seeing reasonable doubt. And I guess if you don't mind, it kind of me shifting to my topic that I was thinking about talking about is just,
please.
We've got Proctor's Trooper Proctor's discipline hearing going on, right? And I don't think there was a resolution for that yet, was there?
No. Today they just announced that he was essentially granted yet another hearing date, and that was announced at the previous hearing date back in January, when they announced that today would be a secondary hearing date. So now he's got a third hearing date, which just seems like an effort to stall.
I heard it was the 13th.
Whatever.
March 13th.
March 13th.
March 13th.
Okay.
Because if they, if on the one hand, here's the thing. This is what I was thinking. If they rule that he's going to be suspended without pay now, and he's suspended from the police force, I don't see how that doesn't come in.
He already is suspended without pay since I believe.
Is it temporary or is it? But it's temporary, right?
I believe.
Suspended, I guess, is temporary. It's not. It's the same thing as being fired, essentially, because you're not getting paid and you're not working. But he hasn't officially been fired yet.
It's kind of sorry to interrupt you, Olivia. She's absolutely right. Like I do a lot of administrative work, and essentially, it's like your preliminary proactive discipline. He's being suspended. He is suspended without pay. He'll have his hearings. I actually had not heard there was going to be a third. That's unbelievable. But when it's ultimately resolved, I don't believe it will be. But by the time of the trial date that's currently scheduled. But when it's ultimately resolved, if he is not in any way disciplined, if there is a finding that this was all a big mistake and he shouldn't be sanctioned in any way or punished, he then gets his job back retroactively, and he'll be entitled to back pay under the regulations.
Oh my gosh.
Right. So here's the thing. If this continues to be drawn out past the Karen Reed trial, so then this fact that he is suspended without pay, that comes in. I don't see how that does not come in. And therefore, if you're the defense in this case, I think in your opening statement, you tell the jury that the lead investigator in this case has been suspended without pay because of the actions that he took in this case.
Yeah.
This is how the Commonwealth wants to present this case. And I don't see how that doesn't come in. I think it's completely relevant, and I think it comes in as evidence. If, he's found administratively okay and he gets his job back, then, that can hurt the defense. The argument is that, well, he was under investigation for this. So on the one hand, you kind of you don't mind if it drags out because you do have that argument. On the other hand, if they come down with the finding that he's fired now, he's terminated, well, then that just adds to the, they have to call him. And if the Commonwealth doesn't call him, that would be someone that I would call as the defense. I'd absolutely call Trooper Proctor and get him on the stand to admit that he's been suspended, or not suspended, but terminated because of the actions that he took on this case. So
yeah, you kind of bring up an interesting point there, Martin, also, because I fully agree. But also I've been on the fence as to whether I would call Proctor in my case if I were the defense team, if the prosecution does not, just because of the different manner in which they have to ask him questions on direct versus on cross. But he's an adverse witness, so I think you'd be able to lead him and use cross-examination.
That's my take. What do you think?
It's different. It's interesting because I've had this happen in one of the jurisdictions I'm licensed in, where I took a position with one judge and it didn't go up on appeal, where I said he's adverse. I want to treat him essentially like a hostile witness. And that particular judge was like, nope. If you want him to hold him as a hostile witness, he has to have offered a certain subset of testimony, either previously or in the evidence that would make him hostile to you. And I just kind of said, you know what, I don't care. So she essentially you're right. I needed you.
And also, he's the lead investigator. That's the one who's charging her with second-degree murder. I mean, how is this not an adverse witness? It's like textbook adverse witness. So
I agree. I should have brought you to court with me, and in our careers, I'm sure we've all been before judges where we're like, okay, is it worth the fight? And that one wasn't, because I knew I could ask direct questions that were not leading to get what I needed. But, many times, at least from my experience, judges do get it wrong. And I make no secret about my opinions that the judge in this particular case that we're here for is making some questionable decisions that I disagree with. But yeah, I think you're right, though.
Yeah. So, I mean, that was just the point that I wanted to bring up about Trooper Proctor and his involvement in this case. And now that he's suspended and then maybe terminated, I mean, like, it's like Furman in the O.J. Simpson case. It's like,
yes.
It's so toxic to the case. It absolutely, what can you trust? It's just, it's so powerful for the Karen Reed side. It's just,
Can I say one difference though between like Judge Ito and Judge Cannoni is that the lawyers were allowed to be lawyers and to litigate and to do their thing. Every time Alan Jackson gets ahead of steam, then Lally would have said objection. He doesn't have to state the nature of the objection. And if he doesn't state it, there are times when Cannoni actually asks him, do you want to object? Mommy has to come in and help because my little baby's in trouble. Let me give him a hug. And then that would stop. Then there would be a sidebar. So then he has to go back to the stand and try to generate all that inertia, all that momentum all over again. And that's the difference, is Lance Ito didn't do that.
Oh, I agree. And it's interesting, DJ, to get your perspective on that, because I'm sure a lot of your audience and just a lot of the people who are on social media now, many of them were like too young to even really dig into the real-time rolling out of the OJ trial. But you are right about Judge Ito and how he he let the issues be fully litigated. And I listened to, it was really hard as an attorney to be, and I'm sure others will agree, to watch the way objections were handled in trial 1.0. And I've heard different reasons why she doesn't put things on the record, or make you put things on the record. I had actually heard attorney Andrea Burkhart kind of digging into it, saying, well, if you don't put your reason on the record and there's a certain type of challenge, then at the appellate level, and this is more in depth, where someone like Martin could even look into this, because I keep things pretty high level. But depending on if there's going to be an appeal of particular evidentiary issues, if the judge hasn't forced a reason to be placed on the record, the appellate court can kind of assume what the under a whole slew of choices, what the objection was for. But it's much more granular than that. I would encourage anyone to watch Andrea Burkhart explain that to Legal Bites, who are both two great attorneys who get into this stuff.
But on the Penny McGee trial, she did allow objections to be stated. So is this okay? You can just pick and choose when she's going to allow it?
So from what I've heard, go ahead, Olivia.
Oh, that was me, Martin, but or Olivia, both of you hit it.
Well, I was gonna just to expand on what Nan was saying, because I remember exactly what she's referring to from Andrea Burkhart's discussion on this matter, because this is an issue that has greatly bothered me as well, and I can give one particular example why. But what Andrea Burkhart said was that let's see, so obviously you all know that she was not, Judge Beverly Cannoni was not precluding speaking objections, rather she was precluding attorneys from stating the grounds for their objections, which a lot of people have been conflating in terms of this discussion. But a lot of, people who think that Judge Beverly Cannoni is biased or what have you, might say that this kind of serves to insulate a little bit from appellate review, because if the appellate courts don't know your actual basis for your objection, then they can essentially consider whether there's any basis that would justify affirming the judge's decision. And so this general principle of appellate review, that they can affirm on any basis that the record will support, gives the judge kind of broad, I guess, coverage, if you will, and also the attorney objecting, even though, the judge is the one who is being reviewed on appeal. But so if Judge Beverly Cannoni pins herself down to reasoning, then that's something that the appellate courts can point to when she misunderstands the law or misapplies it, for instance, and they can point to that to establish error. And in an error in legal reasoning provides grounds to show an abuse of discretion, like not applying the correct standard. So when there's not that specific grounds for an appeals court to point to, I think it kind of removes that avenue for establishing error.
Right. Yeah, that's a good explanation. And one of the other things that Andrea had pointed out in, I think it was that discussion, she, and I think it was her, might have been Melanie Little. I like to drop the names of all the creators because you guys all do some really interesting and different things. But either Melanie or Andrea had said, it's interesting, like it seemed like the most important witnesses for the prosecution would definitely get a break in their testimony, whether it was strictly between the prosecution's questions and then there would be a day or a weekend break and then the defense would have their cross, or if there was an interruption in the cross-examination with a break. And I look at this stuff and go, this trial's, the schedule bothered me, the half days and few days a week, etc. I mean, it does happen, and you can't stop emergencies and holidays. And I even thought, well, maybe there's someone who works in that court who needs an accommodation or something, which they have to give accommodations to employees, for example, if they can't sit too long or have some type of disability. But the breaks in substantive testimony also disrupt rhythm, and bothered me in such a way as the objections without any basis for them being stated. But Martin, I interrupted you.
Yeah, sure. No, so I mean, I spoke about this on my channel a few times, that the idea of the objections, and what my experience with judges, and because every judge runs their courtroom differently, and from what I'm understanding in Massachusetts, the normal thing apparently is that you don't state the basis of your objection, which I think is a little ridiculous also. But if that is the norm in Massachusetts, that's
not in my observation, but I'm not a Massachusetts attorney, so sorry, go ahead.
Yeah, that's what I mean. That's what Judge Canoni said. At least she said that in Massachusetts, that this is how it's done, that we don't state the basis of an objection. Now, to me, there's a difference between stating the basis of your objection and speaking objections. I think that the attorneys know what I'm talking about. But just to kind of explain it to the group, and this is what I explained on my channel, is that if you're speaking objections, you're kind of hinting to the witness what you want their answer to be or what their answer shouldn't be. That's what you're, objection, Your Honor. How could he possibly know if he wasn't even there near that time? That's speaking objections.
And hinting to the jury too.
Yeah, and you're arguing to the jury. Exactly. So there's two parts to it. You're cueing in the witness on what you want the witness to answer or what you want the witness to think about. And number two, you're arguing your case to the jury. So that's where I know that judges do not appreciate, no matter where I am. Like, they don't like speaking objections. They don't mind, and I think it's helpful to have objections, and also keeps the flow when you say the basis. Objection, hearsay. Okay, what's the response? It's not hearsay because of this exception. Okay, here's the ruling and here's the reason. And then you continue. Here, anytime that there's an objection and you want to explain the objection, you have to go to sidebar. Can we go to the sidebar? Can we go to sidebar? So it really, really interrupts the trial, like you're all saying, which is annoying. But also something else that I noticed in this trial, which I mentioned a few times on the trial, which I don't like. And if I was Alan Jackson, I would have made more of a big deal about it, or Yannetti, whatever. Is that a lot of times what I saw was you'd have Lally ask a completely leading question, an improper question, where he's exactly telling the witness what he wants him to answer. And then there'll be an objection, and it'll be sustained, and then he'll ask it in an appropriate way. But you already told the witness what you want to answer. So I noticed this pattern a lot. I don't know if Lally's doing it on purpose or not, but it would be something where I would have a sidebar, or definitely put on the record, saying, Your Honor, this continues to happen where he's asking inappropriate questions, improper questions, where he's leading the witness. The witness obviously knows what he wants them to answer. I make an objection, you sustain it. It doesn't matter because he already knows what the answer should be. So I would have made him. It was upsetting me, just watching it. Like, I see that, and when I'm in trial, I get like, I get like this, where if I sense that you're trying to, play unfair. I'm going. I mean, we all
you're gonna call it
try
out.
to bend the rules, by the way, as a trial lawyer. The rule that it's my own fault also.
But you're not a prosecutor. You're a trial lawyer. It's a different.
Well, I'm not a prosecutor. I'm a trial lawyer. But in trial, my idea is that I know what you're supposed to do, and then I also know sometimes what you can get away with, and I'm always trying to get away with stuff. That's just, that's because I'm an advocate. I'm always trying to win my case and stretch the rules. If the judge isn't going to cut me off or the other guy's not going to object, I'm going to continue. Like, there are certain opening statements. I mean, if you want to be a good advocate, you want to be a good trial lawyer, this is what you try to do. You got to push, you got to keep pushing the line. And eventually, either the person will get tired of objecting or the judge will cut you off. But no, I mean, this is just something that I noticed in this trial. The objections is really annoying for me. I don't like it, and I think it should change. And there's other things about this, the way that the courtroom is run, that I don't appreciate and I don't like either. But that's my take.
I want to say real quick. So Valhalla Law, she's a retired Massachusetts attorney. She's the official attorney of Calling All Beings, because she comes and supports all the time. And she's saying that exactly, I think, what Brother Counsel just said. She conflates speaking objections with her weird no objections rule. So, or stating the nature of the objection. So she's seen probably her in court before. I also there's a question in the chat that I want to throw to you guys because somebody was kind enough. This is Alyssa. She's actually a researcher for this case as well, from Florida. Hi, Alyssa. And she says, oh, wait, maybe I should do the John F. Kennedy accent for this one. Yeah. About the TUI. Were the feds legally obligated to hand over every single thing they found? Or could they have held back some evidence to protect their own investigation? Y'all are legal badasses. So there you go. That was John F. Kinney, one of our heroes.
Oh man.
So
go ahead.
Go ahead.
I mean, I'll take a quick stab at this, but I'm sure that Brother Counsel-Nan can provide much more elaboration. From my understanding of TUI, it's a means by which defense counsel or whoever the implicated parties can obtain materials from an basically a parallel investigation that the feds are conducting. But as far as I understand, I don't believe that the feds are obligated to turn over everything in that production, because this seems to be something I see a lot of people on Twitter, in particular people who are very anti Karen Read, say that the feds have to turn over all of the evidence and have to turn over all of the exculpatory evidence. But that's just not the case, particularly if it compromises their ongoing investigation.
Right.
That the Brady standard is one that applies in litigation between two parties, between the prosecution and between the defense. But the feds don't have that obligation via TUI.
That's I couldn't have said it better myself. And I wholeheartedly concur. There is absolutely no way the feds, who are a third party, if your audience were to think about who are the two parties that Olivia was talking about, it's the state and Karen Read. The feds were brought in, and I don't think any of us knows all of the specifics as to 100% how they were involved into all of this. I think I've heard things, I've read things, I have suspicions, but the federal investigators, and I do quite a bit of cases with federal investigative bodies, not the FBI, but the Department of Criminal Justice, the DEA, et cetera, in my practice. And the federal agencies who are third parties, and in this case, the FBI, which is a third party, their scope is actually very limited. So I'm not going to say to your audience what they are exactly looking at, because I don't know their scope. But if you were to look at, for example, the P. Diddy or Diddy, well, I don't even know his current acronym or name for pop culture. But if you were to look at the Diddy matter, the feds only bring certain types of charges against people. So if there's conspiracy, if there's corruption, if there's the criminal enterprise type of pieces, if there's matters involving commerce and criminality crossing state lines. Now, I will surmise that the feds are exploring corruption oh my God, I'm seeing an animal's rear end cross your face there. Then sorry for the distraction. You know what it reminds me of? Does everyone remember when the pandemic hit and there was the video of the lawyer arguing before a judge and his Zoom was making his face a cat? And he says, "Your Honor, I am not a cat." And, his face was moving. It was a cat, like virtual cat face on him. If you haven't seen that, DJ, you gotta look that up.
Hera always comes in the studio uninvited, but she's gone
I
now.
think she's sending you a message. But the feds are, my opinion, they're probably looking at the corruption piece here. And I believe that they have handed over part of what they have, because they have no obligation to hand over more under TUI or any other case. And I also have a suspicion that whatever they're looking at, which I feel heavily involves the police and the prosecutor's office, which is why I think some of those letters were coming out from Morrissey early on, like, I have an obligation Should I do my John F. Kennedy?
Please, yes.
I have an obligation under Brady. I got to make sure that I disclose everything. You got to give it to me. That's like a mixture of like Brooklyn and
Yes. Dan Gallagher. Woo!
Thank you.
Thank you, Matt. Thank you, Nan. That was awesome.
But he's really interested, and apparently, from what I gathered from, it might have been Aidan Carney's article today. I think it was like there's still communications going on with the new U.S. attorney who took over for Josh Levy from the prosecutor's office, if I read his article correctly. So I have a feeling the feds are going to I think they will intervene. That's my hope and suspicion. I'm going to keep the faith. But I think they don't hand over everything because they want everybody to make their own bed and lie in it, whether it's people perjure themselves, people delete texts, new things get produced. An example would be Higgins, like he testified in at least 2 tribunals that he didn't make any phone calls, and now we find out he did. The feds are going to want to watch that, so there's a full body understanding of how deeply he probably perjured himself. But I'll get off my soapbox and start practicing my accent.
No worries at all, Nan. And for everybody out there in the audience, ask not what the legal roundtable can do for you. Ask what you can do for the legal roundtable. I'm sorry. Go ahead, brother counsel.
Yeah, no. I think that this whole federal investigation is very interesting. The fact that she was, who was it, Christina Rex had asked her, the attorney general, whether there's finality to that investigation.
Yep.
And she basically answered that there's not. I mean, that's basically the way that you answer that there's still going on. And some of the and some of the the anti-free Karen readers are all about, well, if this investigation is going on so long and they haven't had any indictments, that means that there's nothing really there, and this is all just one big lie about this conspiracy. I will say, from my understanding of the federal government and federal investigation, is they take their time. They're extremely, extremely slow, methodical. They have no problem waiting on someone for 15 years, and then we've got all the evidence. You've got it all tight. You're not going to get anywhere now, and then that's when they bring it. So the fact that it's been a couple of years, I don't think that that's dispositive. I think it's interesting. Maybe it's something, but the fact that the new U.S. attorney didn't say that it's over, and that tells you that it's still ongoing, or they haven't put it to bed yet, and the fact that we know that the federal government can really, really take their time, it's still possible that something still may come from it. But I also agree with Nan and Olivia that I don't think we're seeing everything the federal government has. Not at all. I think we're seeing some parts. They obviously handed over the ARCA experts. We don't see everything that's in the attorney's files that maybe they feel is not important or they're not going to bring up. But something tells me that they have a file a lot larger than anything the Commonwealth or Alan Jackson has. So I think there's a lot there that we're not seeing.
And just to quickly add, I think there's 2 main important things that I think provide insight into the federal timeline, or I guess lack of their intervention thus far. And that would be, first of all, the abstention doctrine, which precludes the feds from intervening in state matters. And it's an important rule. It's an important legal doctrine for many reasons, but this is an ongoing state criminal matter. And so technically under the abstention doctrine, the feds, they don't have jurisdiction in this case to intervene, I guess, until there's a resolution on the state level. But beyond that, there's also like Nan and Brother Counsel addressed, there's the issue of how the feds can charge cases. It's very different than how the state can charge cases, what charges are available. And so the key for the feds is finding a jurisdictional hook for charging, anybody who may be due of charges in their investigation. And if you look at how they charged Matthew Farwell in the Sandra Birchmore case, I thought it was a very creative way in terms of a jurisdictional hook for them to still move forward with charges. The witness murdering a witness essentially, because they can't indict on murder charges.
Right. Yep.
And the key difference between that case, of course, and the Karen Reed case is that because that was immediately deemed a suicide, there was no ongoing state litigation that they were intruding upon. So the abstention doctrine wasn't really at play in that case, and they certainly utilized a creative jurisdictional hook. And I think one thing that is telling is that from the TUI, the production of the TUI evidence from the feds, we obviously became aware of the ARCA experts who the feds enlisted to do investigation for their federal grand jury. But we also heard about how the feds have a digital forensics expert who's Quantico trained and works at the National Computer Forensics Lab, who also confirmed that Jem McCabe made that Google search "How long to die in cold" at or before 2:27 a.m. But notably, they haven't let the defense or the prosecution in the Commonwealth's case utilize that witness. And I think that's very telling, because if you think about it, the feds, their investigation in terms of what they may pursue in terms of criminal indictments, that would have nothing to do with a car accident, right? Because if they're pursuing corruption charges or however they may go after individuals potentially in third parties in this case, or investigators in this case, it would be all about the cover up or evidence that incriminates them, not evidence that exonerates Karen Reed. So the ARCA witnesses, ARCA experts are experts who exonerate Karen Reed, but the 2:27 a.m. Google search witness is somebody who incriminates Jem McCabe, which, in the Fed's view, that's not necessarily necessary for Karen to exonerate herself or to prove reasonable doubt, I guess, in the state's case. And I actually think that kind of speaks volumes. Who knows what the feds are going to do, but I think the fact that they're holding that witness back is significant. And to me, if you want to read tea leaves, suggests that perhaps they're holding that digital forensics witness or expert witness back for their future indictments or for their, potential future prosecution of individuals in this matter. So,
I hear what you're saying, Olivia, about the feds concentrating on their case as opposed to Karen Reed's case. Although I think everybody would agree that if the search was done at 2:27 a.m., I mean, that screams reasonable doubt. That absolutely helps the Karen Reed case. So,
no, I'm not trying to take away from that fact, but I guess what I'm trying to say is, if you look at the feds in their if they were going to proceed with indictments of the people they're investigating, it would be more important for them to prove, I guess, criminality of those individuals involved in their case in chief.
Right.
I mean, it's just, it's hard because the feds don't give any transparency into their investigation. So of course you kind of have to speculate on a lot of these things. But I was just asking myself why they won't allow the defense to utilize that expert in the state proceeding, and then looking at, which experts they did allow the defense to utilize. It's like, that's an interesting distinction, in my opinion.
Yeah, it could be also because I'm sorry, go ahead, Nan.
Oh, no, I completely agree with you. And I never thought of it that way. And it's almost like the feds are giving up just enough to exculpate Karen, meaning John O'Keefe wasn't hit by a car, but they're not giving up something that could inculpate Jen McCabe or others in the circle of trust.
Yeah.
And that's like and that's kind of how I'm interpreting some of the way above my head analysis that you do, Olivia. Like, seriously, it's otherworldly. It's like calling all beings. How about that for a hook, guy? But seriously,
I wish I had thought of it. It was Nathan, but go ahead.
This is a clear example, in my opinion, about how crafty the feds are. And Martin's 100% correct too. They take their time, and they do so and have such very, very high conviction rates. Because they take
like 99% high.
Yeah, like there are reasons. Just one brief aside: the killing of the United Healthcare executive in New York City, which ended up bringing both state and federal charges. One of the reasons people were buzzing about that afterwards, who are interested in true crime, as am I, was that, like, people who know the way the federal offices, the federal attorney's offices in New York and the state prosecutor's office in New York, like, these are top-notch offices. Everyone was saying, how stupid, if you were going to kill this guy, were you going to do that in New York? Like, that's a bad move because of the high conviction rates. But anyway, Martin, go ahead. I interrupted you.
Yeah, I don't even know what I was saying. I was just sitting here spellbound by your brilliance.
Yeah, Olivia, seriously, like,
I mean,
unbelievable.
Yeah, no, I'm sorry. Now I forgot what. Now I forgot what I was going to say about this situation. So forgive me. Go ahead. Yes,
DJ,
ma'am.
I got a
Well,
question.
I was going to say that it could be that, you know, the federal government's not going to offer this expert of the 227 search is because they already have Richard Green. So, like, if the federal government doesn't feel like we can, you know, they didn't have ARC experts, they didn't have accident reconstructionists.
Well, they did have Christopher Van E, who they didn't ultimately call. I believe his area of expertise was more, I guess, he was more an expert in things like key cycles and vehicle data, not, you know, an accident reconstructionist perhaps in the way that the ARCA witnesses are, but yeah, so you're saying you think that perhaps it's because the defense didn't have that type of accident reconstructionist witness on there.
Yeah, and I mean, it almost seems like the federal government's saying, look, you need to beat this case. Here's what we're going to give you to beat this case. You got the ARC experts. We're not going to give you everything else because that's enough. You know, so like they're kind of like measured with what they're actually going to give. By the way, I just saw a chat from Tiff, and
Tiff,
I appreciate Tiff because she sends me some of the legal documents in PDF form, which is just great. So I just wanted to give a shout out to Tiff. I appreciate her sending me you know, the legal documents, and anybody else who wants to send me legal documents, send them all to my email. It's you know, it helps me. I don't have to go searching for these documents.
That's awesome.
She's very kind. She sent me a DM as well. Thank you, Tiff. I do appreciate that. And she was giving me ideas about the panel and so forth. So thank you. I was just going to say this is extremely passé, but that if you look at how the Donnie Brasco case, when they pulled him out, they didn't pull him out until he was going to become he was a made member of the mafia at that point, and they asked him to go make a hit, and they had a mountain of evidence, but they didn't pull him out until, and he actually wanted to continue gathering evidence, and they said no, Joe, it's Joe Pistone is Donnie Brasco in real life, and they said no, we're going to have to pull you out. So I think what they're trying to do here is to allow things like the Jennifer McCabe messaging Mike Morrissey, and then him further having ex parte communications with a judge who was ruling on a Chris Albert protection order against Turtle Boy, and then you have Jen McCabe, and you have Kate Peter, and you have you know, the ex parte. So I think they're going to allow them to feel safe. I mean, Chris Albert even had Twitter exchanges with me where he said, "Oh, where are the feds? I'm here. You know, I'm in my backyard. I'm by the pool. You know, what's happening?" I mean, I'm going to be too old for them to arrest me. So I think they feel very safe. And I think if the feds I think they're quite happy that they feel safe because they'll continue someone like Jennifer McCabe will continue to do stupid things and implicate herself and weave herself further into jeopardy when she doesn't need to. She could just keep her mouth shut and go to lacrosse games. But instead, she's an idiot emailing Brian Tully and Morrissey in the middle of the night because she's a moron. Whereas Brian Albert, you see him, you don't hear a word from him. I got away with it. So far, nobody hears me.
Yeah, it's so funny you say that. There's a sign hanging right behind my desk. Actually, it's in front of my desk. And I have a bunch of inspirational signs up. And one of them says, "The fish got hooked because it opened its mouth." And, I say that often to clients. And I think Jen McCabe is probably being too bold and has been too bold in communicating to individuals in law enforcement and possibly the prosecutor's office in terms of asking for relief or protections or things that she feels she's entitled to, or that she's been aggrieved or her family's been aggrieved. I think she better watch how she goes about doing that. And I do think ultimately there will be a reckoning. There's too much going on here for people who really understand that this is so clear cut. It's not just, well, there's reasonable doubt. There's so much more than reasonable doubt that leads people with critical eyes to say, it absolutely couldn't have been Karen Read. At least I'm speaking for myself. It could not have been Karen Read. So it therefore has to have been a conspiracy of sorts. Unless the 227 search happened and it was Jen McCabe who killed him and it was one person. But the reasonable minds would say, no, it had to have been at least two. The person who Googled 227 and a killer. And, when you start going down those, I'll keep your show G-rated, DJ, but when you start going down those rabbit holes, it can really lead to some really troubling thoughts about who's in control up in that county up there in Massachusetts. And you say, something's got to be done here. And I think the feds will get to the bottom of it if they haven't already. It's very possible that they have, and they're just, for the reasons of that policy that Olivia and Valhalla Law, I think that was her handle.
Yes, Valhalla Law. Yep.
Yeah.
That's her.
She's smart. I'm going to have to start following her more of what
I can connect you. Yeah, she's a retired attorney. Yep.
And also, don't forget that Vanity Fair also hired somebody a company that also confirmed the 227 search. So that's another independent source.
That's right. Which I thought I saw on social media. And, just because it's up on social media, it doesn't mean it's true. I could have sworn I saw in the last month or so that person engaged or questioned by Vanity Fair might have scaled back his opinions in some type of interview or some type of article. I could have sworn I
think it was somebody who posted on Twitter that somebody who's staunchly anti-Karen Read, I guess, reached out to him. I don't know the extent of that communication, but I mean, who knows?
Never believe what you hear on Twitter.
Yeah, well, I mean, I'm going to be
an official issuing of, like him retracting his, but
well, I'm going to be a little unpopular here because, I've always maintained, I've always maintained on my channel that I don't know 100% if there's a conspiracy. That's how I've said it. I think there's absolutely reasonable doubt. I know Nan is, believes that there's some sort of conspiracy. I think there's a lot of questions here that need answers. I think there's a lot of coincidences if we're going to be chalking it up to coincidence. I can't say I know what happened, who was involved, and I don't want to say one person over the other because there's just too much I don't know. That's what I want to like. I think that there's a lot of information out there that we don't know because the either investigation was protecting the Albert family because he's a Boston cop or other reasons that the investigation wasn't done properly. But like I keep saying, like one thing is clear is I don't know what's going on. And I'd like to know, but I'm not going to just right away say, well, that person was absolutely involved and, and hang that person out to dry, whatever. Like, I'm a little
There's
bit
a lot
guarded.
of reasonable doubt, right?
Let me give you one thing I think I figured out. And thank you very much, Larry Ledge. And by the way, we have your stuff starred. Those of you who have asked questions, and even when Brother Counsel has to get out of here, what we'll do is we'll go to those questions in the chat and see if we can get Nan and Olivia and Bea and stuff to go after those questions. But I just want to say, one of the things I think I figured out is that I was trying to solve for X in terms of the crime. X is if I have two officers of the law that decide they want to fight, and that was apparent from all the videos that Brian wanted to fight John. He wanted to send John home with a black eye and say, Karen, you picked the wrong guy. And then so they agreed he has to go and show up over at the house, because if he doesn't, then Big Mouth Higgins is going to go around to Canton PD and use some very unflattering names for guys that turn down offers of fights. And I'm not going to say what some of those names are. So he has to at least show his face in there. He tells Karen, I'm going to wait right here. I'll be right back. And then he doesn't know, no, you're actually going to fight, because Coach Brian Albert's been getting him all fired up to go down in that gym where he probably trained his boxing and so forth. But what I needed to solve for, if two guys get in a fight, there's nothing illegal about that. I could agree to fight anybody and have a fight as long as it's not in public and we agree we're going to fight. There's nothing that's against the law about that. So when they go down in the basement, something had to happen, because if they're at a hunting camp and you have Higgins, Albert, and O'Keefe and other officers, and John O'Keefe falls and hits his head and his head's bleeding, they're going to call 911. They're going to say, oh, dumb O'Keefe just fell and tripped coming back from taking a leak. We got to go call 911 because he cut his head open. And if they had a fight and he fell in the weight room at Albert's house, also a crime has not occurred there if they agreed to fight. But if someone hit John with an object, now that's a felony right there. And I just found out that if you commit a felony, you may not get your retirement. So
yeah, their pensions and stuff like that.
Exactly. So that's why I believe a crime was committed that Albert thought he couldn't explain away. And I also want to say one more thing. Brian Albert, because they were both at Boston Police, would not only have to call 911, he would also have to call the duty desk, the duty sergeant. And when the duty sergeant answers that phone, that is a recorded phone call, and that is the report right there. He's typing a report. Okay, you say O'Keefe had to go to the hospital. What happened? Who was fighting? I'm typing. Okay, what time was it? Who did what? Who? Now, there's a whole record of this thing that he probably didn't want to explain away. And that's why I think a felony was committed, and they decided not to. That's why they didn't call 911. If it was an accident, we'll just call the ambulance. These guys had a fight and there was an accident. Just call like any two guys that get in a fight. So that's my take. And go ahead, guys.
But I think that Brother Counsel's point is important to remember, and important to focus on. The issue is not about solving the case. That's the Commonwealth's job. That's the police's job, and that's not Karen Reed or her defense's job. You can't blame them for, if Karen Reed is truly innocent, and this is a cover-up, and what Steve Scanlon called David Yannetti and informed him of on February 2nd after he's leaving her arraignment, which, by the way, happened before any of the photographs or details of John O'Keefe's injuries were public. So I find it incredibly coincidental that he happened to know that a dog was attacking and biting John's arm, because nobody knew about those injuries. But besides that, proving what exactly happened, that's not of importance here. What's of importance is that the defense, they don't have to prove anything. They just have to raise reasonable doubt. And the fact that the federal government has turned over significant evidence that raises overwhelming reasonable doubt, and the prosecution has still proceeded forward, I think speaks volumes about the integrity of this prosecution and, of that office. But importantly, I think go ahead, brother.
Yeah,
I know you have to get off soon. So.
It seems like there's a lot of pressure to bring this case. I think that if this didn't have the same publicity that we have and all of the movements, I think if this was a quiet town and in Michigan somewhere, the prosecutor would have looked at this case and said, we're not going with this case. Like there would have been a sweetheart deal or something, and then this case would have gone away. I think the problem here is that because of this all conspiracy talk, and because we got all these people who are are kind of under the gun by a lot of people that feel that they're part of the conspiracy, like they feel like they need to stand up for themselves and
it's become personal for them,
right?
But that's entirely the problem, because
there's I think a lot of outside
justice.
Yeah, I think there's a lot of outside pressures here at the work, which is why we keep seeing this case, even though I mean, literally everywhere you turn now, it's just like another thing. It's like now Brian Higgins on the phone at 1:34 in the morning, and that video was never turned over, and that's not a Brady violation. And there's going to be a motion to dismiss, which most likely, as we all know, is going to be denied. Is there basis for that motion to dismiss? Definitely. That's like textbook Brady violations right there. It's exculpatory. What's with those videos? How do these videos sit there for 2 years dormant? No one ever turned them over. And then a week before trial, and then during trial, and then after trial.
After trial.
I mean, it's any lawyer in the world is just like what is going on there? Like, this is obviously there's something wrong here, and there's just everywhere you turn in this case, there's just more questions than there are answers. And then you still see that they're still going on with trying this case and trying to get a conviction. Hiring more experts, and they're going to have some. Again, I don't know how this expert is going to explain the wounds to John O'Keefe by the car. What's so interesting? I don't know if you guys do this, but every once in a while I'm somewhere and no one knows about the case. I say, here, let me show you a picture.
Yeah.
Tell me what caused those injuries. I mean, just a random person. Just a random person. Tell me, give me some options. No one ever says an option of being hit by a car. No one.
Brother Counsel is scaring people on the streets of Michigan. Look at this arm. Look at these scratches. You just tell me. It's like man on the street. I love it.
Yeah, just like anyway, just random. Like what not a random on the street, but like people that I know. But like let me just ask you a question. You ever heard of the Karen Reed case? No. Okay. Here. What are these from?
Yeah. You know what?
Not knowing anything. What's this from?
ChatGPT says that the John O'Keefe's arm injuries were most likely caused by a dog or animal attack. I mean, that's pretty incredible.
Can we have ChatGPT be the jury, Olivia?
Yeah, I know, right?
Sorry to interrupt you.
I just want to say to Olivia just real quickly. When I give my hypothesis, I'm not acting as an attorney, the prosecution, the defense. I want to figure out why somebody didn't call 911 when John was hurt. That's just me. That's I want to solve for X. That's not what that is definitely not what the defense need to do. And Brother Counsel pointed that out on his show. You are not trying to prove a conspiracy here. Reasonable doubt.
And that's why I've always said that I question, the strategy of the defense to try to prove a conspiracy. I always felt it would be a better strategy just to show that there is so many questions here and coincidences that we don't know what in the world is going on with this case. And that's all. And because we don't know, that's reasonable doubt. Instead of trying to spin this whole conspiracy, which
I think, I think that, sorry to interrupt you, because I really want to ask you a legal question before you leave. I know you have to go soon, but really quickly on that, I think from what I've observed since the beginning in terms of the procedural history and the facts of the case, it appears to me like the defense has been doing everything they've been doing since the beginning because they want to get justice for John O'Keefe. Karen wants to get justice for John O'Keefe. It's not just about exonerating herself. It's about also getting justice for, the man that she was with. And I think that gets lost on people oftentimes. It's not about, trying to throw blame elsewhere. They've been following the evidence literally. But Brother Counsel and Nan, I would love to get your guys' take on something in terms of, from your experience as attorneys. And that is, looking at how much time has elapsed since the close of the first trial, which was July 2nd of 2024, until the time that the Hank Brennan just filed his certificate of compliance. So he, turned over all this discovery, which, as we've since learned, encompasses thousands of new pages of discovery, new topics, new experts, etc. The Commonwealth has had approximately 220 days to file evidentiary motions, to file Daubert challenges, to get its experts' analyses, and to turn over discovery to the defense. The defense has approximately 2 weeks to file all of its evidentiary motions, and approximately a little less than 2 months until the start of trial. Is this normal to you guys in your experience, in terms of, I guess, the fairness in terms of how much time each side gets, and also just in terms of how much time a defense team gets with the discovery and preparing for trial?
Yeah, I mean, I'd be happy to answer that from my experience. When a defendant has waived their right to a speedy trial, and I mean, I think it's abundantly clear Karen did that, and even had her first trial. This is unusual. I was actually saying something about this yesterday on Brit Happens. I was chatting with attorney Andrew Meyer. And yes, she's got a baby. She got a baby channel. Everyone should go hop over and give her a like and a subscribe as well. But that's a great insight there, because the prosecution does have all of this added time to get their ducks in a row. And we see the same thing, by the way, in civil litigations. In civil litigation, by the time the plaintiff files a complaint, they should have done all of their due diligence and gathered all of their medical records, data, experts, or at least knew what type of experts they were going to have, etc. And then once they file a complaint, the clock starts ticking for the defense. In this case, to have all of that time for the Commonwealth, and then these short deadlines, very, very tight in terms of when certain things are due for the defense. This is unusual when there's been that waiver of a speedy trial. Martin, what do you think?
Yeah, so the way it works is that, both sides are preparing as the case is going. The defense is not waiting for the prosecution to finish all their discovery and their discovery dump before they prepare their case. They're obviously preparing at the same time. Of course. So, the idea here is that this is the opportunity for the Commonwealth to give over all the discovery and say, look, this is going to be our case. And now you are building your own case. But now that you see our case, maybe you want to add some things. Maybe you want to attack some witnesses, maybe add an expert here or there or the other thing. So they don't believe that they need to give so much time for the defense to be able to, to prepare now, because they've really been preparing the entire time. It's just a question of rebutting now what the Commonwealth is presenting in their case in chief. And what we do find is that there's a motion to extend dates. So we just this is a motion filed, I think it was today or recently, where they said we just got this discovery dump, and we need some more time to go through this. We need you to extend dates, and therefore, you do find that. And if they feel that they need more time, they can definitely make a motion with the court and say we need some more time to go through all these exhibits and documents and see what type of response is necessary, if we need to hire some new experts now or whatnot. So that is being done. They did. Go ahead.
As you probably recall, Judge Beverly Cannoni, in what I thought was exceptional, because I don't think I've seen it before. Before the last trial, the Commonwealth and the defense filed a joint request for a continuance,
Right.
because they had received 33,000 plus pages of TUI evidence, and the trial was weeks around the corner. And Judge Cannoni, I believe she denied that continuance request. And, when it's both sides jointly asking for that, I haven't seen usually a judge is going to allow that request. So I thought that was notable.
Well, I mean, I've had when we joint requests and the judge just wants, let's say, for example, for the trial to go, and it's been being adjourned for one reason, another reason, and even if both attorneys want to adjourn it, the judge's like, no, we're trying this case. We got to clean our docket. clear a docket. So that does happen even when both sides want something to be adjourned. Although that happened with to adjourn this trial, which is supposed to be going on right now as we're sitting here. January was the 25th initially, and they both made a joint motion to adjourn it, and she did grant it. So it does happen if there's reasonable basis to adjourn it. The judge will and should.
Wouldn't an ongoing federal investigation be, certainly cause for concern? Maybe a reason why a judge might be like, well, maybe we shouldn't be rushing into this trial.
I don't think the state's going to concern itself with the federal investigation. I mean, that's the state's going to run with its the same way they're not going to concern themselves with the Supreme Court decision that we're all waiting on. They continue business as normal, as if nothing else is going on. That's my experience with the state judges. So even if there's a federal investigation, even if there's a Supreme Court, if there's an appeal going on, unless you file something for a stay, you file for a stay or something, they're going to continue. They're going to plow through and they want to clear their docket. So unless you have a good reason, unless you have a good basis to adjourn the dates, which again they just did file that motion, the judge is not going to grant it. So yeah, that's kind of my take. I'm really sorry. I got to jump.
Thank you so much.
Thanks for staying extra. I appreciate that.
It was nice to meet both of you, and it was nice to be on the channel. DJ, can I get one round of applause?
Yeah, absolutely.
That was so great.
Here we go.
Thanks, Brother Counsel.
Thanks so much.
Thank you. I hope you'll come back.
Brother Counsel, give me an amen.
Woo!
In the chat,
everybody go
Counsel.
subscribe to his
Yeah.
All right. Thanks a lot.
Bro.
A lot.
We've got your channel pinned to the top of the chat. Peace, man. Bye, brother.
You know what I
All
wanted
right.
to ask him? I knew his time was running out on the show. I wanted to get him to give his take on interviewing or meeting with Kevin and Kate. I know he was discussing it on Aiden's channel, but now that he's really had a time to reflect, and now that because he was interviewed by Aiden Carney 2 days after, I think it was 2 days or 3 days after, or something like that.
Aiden's interview was scheduled before they reached out to him
after
they heard about Aiden's scheduled interview and scheduled that show.
And now that they've had this, he's had time to reflect. He's also had time to get a lot of friction from anti-free Karen readers on social media that I've seen. I mean, he keeps himself so even-keeled and equitable. I have much respect for that. I get fired up. But I'd be interested to see what his take was on just kind of discussing these issues with them and seeing if his opinions have changed. I know he probably feels like a little bit like I currently do, which is, oh my God, I feel like I jumped in with a surfboard, on a huge wave.
Yeah,
I could ride it.
You're chasing mavericks out there off the coast of Santa Cruz. There's like a 50-foot wave.
Oh man, they hate me. They hate me, DJ, but that's okay. I don't care.
They probably hate me too.
Well, this side loves you, Nan. So that's all you need to know. And can I just say real quick, I know you have plans on coming to Boston, and I would love to introduce you and take you around, take you to 34 Fairview. Let's go to CF McCarthy's, the waterfall, and I will introduce you to all the boots on the ground. So I would love to host you for the day. So let me know.
That would be great.
I'll go in the area, so.
Thank you. Thank you. I'd be happy to do that. Although you got to take me to whichever one of the establishments I can get a meal of food at. And
both. I was at the waterfall 2 weeks ago, and if you see how I was at the third table from the bar, the high tops that they talked about so much in the trial. So at both locations, you can get a meal of food, and they make a really good espresso martini. Just saying.
Ooh, I'm in. And
we just had a meal of food with like 100 people and in Dedham. At a restaurant I won't name here because we won't go there again because they were very mean to us. But we started out with 20 and it blew up to be about 100 people. Turtle Boy was there. Brian LTL, your other host, was there. Mazza was there.
Nice.
Britt was there. I was there. Beatrice was there. So yeah, I mean, Olivia, I was going to tell if Olivia showed up, I would have let her sign Olivia Lambo on my face in Sharpie, but she didn't come. So.
But yes, man, I'd love to show you around and just
Absolutely.
When you see 34 Fairview, girl,
Everybody I see who has been to the site, including the LV cops, like everyone's saying, okay, wow, this is actually smaller than things appearing up close. And, you know, I really, as an outsider, approach the scene of 34 Fairview and I say, all right, well, maybe you know, if you're not looking for a body, maybe you wouldn't see it. But then I look at the pictures and then I think of, yeah, there was snow and he would have been a dark figure. And, you know, there's no way where cars were parked and people were coming and going.
So I just let you know one thing? Somebody actually from Canton, just a couple of days ago, we had snow. The road kind of starts to curve. They were on a truck and they actually showed what it looks like as you're going up the street from the driveway. As the road curves a little and then you see the flagpole, you could have seen everything.
Yeah, I mean, Lucky Loughran, or Loughran, I'm not sure I'm pronouncing his last name. He's a fellow Irishman. I should get it right, damn it. But he's like, God forbid any animals. I mean, this man is like the Terminator scanning. I think you guys might be old enough to remember the original Terminator where they literally just scanned the scene to make sure that there wasn't something notable like Sarah Connor popping out that he needed to lay eyes on. That was Lucky. Lucky is the Terminator.
Incredible.
Yeah.
Lucky deserves
Aiden's next T-shirt. You know, give Lucky the Terminator eyes and have him scan the scene.
I don't know if you guys want to say hello to Michelle Littlefield is in the chat. Do you know? I know Olivia knows.
Michelle Littlefield. I think she's incredibly brave. She's like another one of those heroes in these cases because she had the brave. So she was name dropped, if you will, in one of the Betterow letters where Mark Betterow, who is one of Aiden's attorneys now, revealed the communications between witnesses in the Karen Reed case, specifically Jennifer McCabe, essentially communicating with Michael Morrissey, or, you know, somebody was communicating her personal thoughts and feelings with Michael Morrissey, who then, using his personal iCloud, which some people call burner account, email account, emailed sitting judges and court officials on behalf of Jennifer McCabe's feelings to tell them that he didn't like essentially how they ruled on. So if you recall, Chris Albert and Jennifer McCabe both sought out HPO's harassment prevention orders against Aiden because they didn't like his reporting, and they were both denied, which just makes it all the more remarkable to me that the DA's office pursued witness intimidation charges against him, because, you know, the bar is certainly higher in terms of probable cause for bringing forth charges like that than it is to obtain an HPO. But nonetheless, both times, both Chris Albert and Jen McCabe's attempts to obtain HPOs were denied by the two different judges who heard, you know, their arguments or read whatever they submitted. And yeah, long story short, Michelle Littlefield is the woman who came forward to Mark Betterow or whoever with Aiden's defense team and revealed that despite the fact that the prosecution or DA Michael Morrissey's office was not allowed to go through any of Aiden's phones or devices, they had to go through a taint team, and they had represented multiple times in court on the record that they had not gone through his cell phones or devices. Well, Michelle Littlefield had been basically presented with a Celebrite extraction of Aiden's phone from, you know, a year prior, right after they arrested him. And because she was essentially threatened with her job because somebody found on Facebook, I believe, that she was, you know, friends with somebody who followed Aiden. And so therefore that meant that she had to be the individual who in Michael Morrissey's words, leaked public information to a journalist, which is not leaking, because if it's public record, then it's public information. So there's no reason why she should have ever been threatened or intimidated and lost her job. But because Jen McCabe was shocked and horrified that the judges denied their HPOs. Michael Morrissey had to reach out on his burner iCloud account
to Judge O'Malley.
So that's the background. Sorry, that was a little long-winded, but that's
no,
the
I needed it.
that. The Betterow letters are incredible pieces of work and full of information.
I've heard in some channels that the Betterow letters, which I have read, I forgot Michelle's name was in there. I've heard that the Betterow letters are going to be preserved and hung on display in the Smithsonian.
Yes, they should be.
They
should be, because they're so well written and they're so scathing. What Michelle, though, what she's saying here on the screen here that a lot of people don't know, and I didn't know until she called me, she was a private investigator for 30 years. So
no way.
Yes, she was.
Oh, that explains so much, because I mean, I'm not a private investigator, Michelle, but I did look you up. You know, Google is a wonderful thing, and I was so impressed by what you and I believe your husband had done, you know, in regard to I believe it was in regard to the casinos and that whole battle you guys fought, like on the local front. But that's completely independent of this case. But I mean, like, it was just such a badass thing for you to do, and I thought that was really impressive. So that makes a lot of sense if you have a background as a private investigator. That's so cool. And you still are one.
Yeah.
Yeah, I'm definitely at some point I want to connect with you, Michelle. I have questions, and now that I know, you know, put a name with the relevance in all of these kind of converging storylines, which is what I see Karen Reed and Aiden's case as being. I definitely have questions for you and or want to follow you. So that's great.
Well, I can connect you. So we got to connect you with Valhalla Law and Michelle Littlefield.
Thank
and
you.
we'll make it happen.
Thanks, DJ.
I'll jot it down.
And I can send you, Nan, I can send you those Betterow letters too, if you're interested.
Oh, I have read them. Those I have
okay.
read, but to the extent, like with the amount of processing my brain can do, Michelle's name didn't, you know, it was one of those things where I'm like, I know that name, but don't really know it. So now that I know it, I'm going to read them. They will be my bedtime story this evening.
Great bedtime reading, that's for sure.
I know you do it too, Olivia. I'm sure you do. There's no way you can slice and dice this stuff without.
Oh my gosh. I mean, I say this case keeps me up at night.
Me too. Yeah.
We've all had sleepless nights because of this case, and we're just really glad that Nan is here, that we have another attorney that's on this, because without you, you know, we wouldn't know, you know, all the ins and outs of what the lawyers are doing, what they're thinking, what they might do, what they did right, what maybe they didn't do right, that they should rethink, etc.
I'm opinionated, DJ. I am opinionated.
Aren't we all? That's why I have a channel. People are like, well, what? People said, why are you speculating about what happened in the house? That's why I have a channel. That's so I can do that. That's why. Yeah.
And
Nan is well versed on all in the YouTube streets too. She knows the lingo. I hear you on the other shows. You're so good.
Thank you. I've had some slips though. Like I had to say KP during one, you know, made sure I said KP. I called Higgins Higgy
Poo, right?
Higgy Poo. That's my name for him.
But seriously though, at some point I saw someone invite, like, I'm still kind of acclimating to Twitter and X, and somebody said, "Hey, we're on JFK, come hop in." And I've watched JFK's show before, in parts of it. And then I hopped into the chat the other day, and I swear I was like, this is almost a foreign language in terms of the chat speak.
Yes.
You know, so I am getting there. I will immerse myself in all of the lingo.
Yeah, we're gonna have on James Jackson from that show I don't know, it's in a week or so. So
Yeah,
we're going to
it's
host.
next the 17th, DJ.
Yes, and
I'm
we're
gonna
going to
be
have
watching
all
that.
kinds of fun. Beatrice and I are going to have a certain mode of dress on. It's going to be really cool. So,
Oh, that's awesome.
yeah. Now I have a question for the two analysts here, and I'm sure Bea has some questions too. And we got to get to some ones from the chat. So
Yeah.
let me
So
throw
focus
this
on
in.
that.
Okay, you want me to do that then?
No, I'm just saying, like, when you're done with your
Okay.
question.
Yeah, when I'm done with the question, we'll go to listener questions here. But I wanted to ask you guys: do you think that what relevance do you think the officer from Dighton, Officer Barros, has? That if he comes and then I assume the prosecution won't call him. He will end up being a defense witness in this trial, and then he'll be cross-examined by Hank. So what do you think how do they get around him saying, when I saw the tail light, it was not smashed. It had a crack in it and a piece had fallen down inside. So I want you to let me know how to me, that's ball
Show 'em
game
a
right
picture.
there. Yeah,
That's what
he's
I
the
would
only
think.
one that has no he's the only impartial police officer in the case. So tell me what you think about that, Nan and Olivia, please.
Interesting. Olivia, did you want to go first, or I'm happy to?
Yeah, you can go for it.
So
The floor is yours.
thanks. I think that the prosecution needs Barros. First of all, I completely feel that Officer Barros is one of, if not the most honorable law enforcement officer involved in this absolute mess. But I think they need to produce him because he is part of establishing the chain of custody. Now, one might say, no, they're not going to use him because the chain of custody is a complete. Am I allowed to curse on your program, DJ, or no? Do you want me to?
Yes, sure. Go ahead. I know you're going to say S show.
Yeah. Well, see, my T-shirt tonight says "Good moms say bad words."
Yeah.
So, but anyway, you know what? Let me keep
Love
it.
it.
Okay.
I will keep it honorable this evening. But it is the chain of custody has been compromised throughout this investigation. I feel that Barros is needed. I also feel that a prosecution will call him, and the prosecution knew when they called Barros the first time that he was needed, and they knew that he was not going to go far enough to say, either he didn't see it, the tail light, or that which they would have been fine with if he didn't see it, but make a finding as to the quality of the damage to it. Or they knew ahead of time that at most he was going to say it was cracked, but not fully broken. So Barros is, as I see it, a necessary witness for them to establish, hey, here's how everything came along. The murder weapon went from Dighton to Canton, etc. So I think there needs to be, if I recall, he was not cross-examined by thank you for shaking your heads, because, this
He was not. He was
so
not.
he needs to be cross-examined, and I think the cross-examining may not even really feel like cross, because once Alan or David or Robert go at him, I think Barros, as much as it may be uncomfortable for him, he wants to go there. He wants you to be able to ask him these questions, and I think he's going to make a concession that it was really just a crack, and he did take a good, robust look at it. What do you think, Olivia?
So a few things. I think part of the reason why the defense didn't cross-examine him at first trial is, everybody, you have to realize that, and I know, Nan, I know of course you realize this, but the defense, they did in Massachusetts, you can't depose witnesses in a criminal trial. I mean, rarely, I don't believe that's common practice. I don't know that it's even allowed. So in other words, the defense didn't get any opportunity to question witnesses like Nicholas Barros before the trial. So, you know, they have no idea what he's going to say, because clearly the police reports in this case are not reliable.
Right.
And I don't believe there's any, I don't think that it's like, you know, in the police reports that do exist, the police did a incredible job at avoiding asking witnesses pertinent questions. Like, I mean, they allegedly hear Karen Reed making these admissions on the scene, but yet neither Michael Proctor nor Yuri, and that was their probable cause to go seize Karen Reed's car and her phone and interview her. But yet when they interview her, they ask her nothing about why she was allegedly making admissions at the scene. I mean, wouldn't that be one of the most important things? Like, hey, why were you purportedly confessing at the scene? Like, that's why we're here to talk to you. But that's a whole other conversation.
Right.
Back to Nicholas Barros. I think that, you know, obviously this trial, I think, is going to be so different for both sides, but especially for the defense, because one thing I did prior to the first trial was, once the witness lists were released, obviously, you know, anybody who was watching the pre-trial litigation knew who, like, Michael Proctor, Yuri Buchanan, you knew like who the different players were, but there of course were witnesses who were revealed on both lists, especially the defense's list, that a lot of new names. And so I kind of looked into all the witnesses on the defense list that I hadn't heard about yet before in the documents or any of the pretrial litigation. And one of the witnesses who was on their list is a woman who is neighbors with Karen Reed's parents and lives across the street from them. And I actually looked up her house on Google Street View.
Street View.
Yeah. And because I'm curious, does she have any cameras at her house, right? Because I think one of the, there's so many things that happened before the first trial that people who weren't following it then just aren't aware of. But one of those things was the defense had the footage from Karen's parents' house this entire time, and they were begging the prosecution to look at it, to request it, to enter it into evidence. It was exculpatory. It shows not only Karen Reed's taillight intact and functioning and glowing bright red, but it also shows what I believe is the key cycle that the Commonwealth tried to put forth as the incriminating key cycle, because in that key cycle you can see on video as the tow truck driver is reversing the vehicle out. And well, what do vehicle systems record? They don't record the distance being covered by a car. They record the distance which is necessary to calculate the speed forensically. They record that by how fast the tires or the wheels are spinning. That doesn't necessarily mean that they're making contact with the ground and moving over that length of distance. Right. So the defense in the pre-trial litigation, they had been begging the prosecution, like, why haven't you requested this video footage? And it's amazing how the Commonwealth in this case not only avoided retrieving critical surveillance footage, usually the first thing done in any criminal investigation, but avoided, but they also just had no interest in it. I mean, like with everything we're seeing right now with the Sallyport footage, and so the Commonwealth finally filed this motion, which I encourage anybody to go back and read, which was their request for the alarm.com footage from Karen's parents' house in Dighton. Mm-hmm. And in that request, it's so arrogant, because they're basically saying, we don't buy the defense's theory of a conspiracy, or there's no evidence of police corruption in this case. And so we're finally filing this motion to request this alarm.com video footage once and for all to prove that Michael Proctor didn't lie about the time that he towed the car back to Canton, and to prove, you know, all these different things. And then it's amazing. Once they got that footage, you didn't hear a peep more about any of those boisterous claims they made in the filing, because of course it proved Michael Proctor did lie about the time that he towed the car, which now allows for planting of evidence and so on and so forth. But that's a long way of saying, if you look at their witness list, that neighbor who lives across the street from Karen's parents' house, they have a camera pointing right on the road, where you can see the flatbed tow truck is parked in the road where it's brought, you know, where Karen's car is brought out to. And essentially that camera, from what I was able to see, is pointing in the exact direction that would show the back of Karen's vehicle. And so I'm wondering, you know, if that witness is being called for that purpose. I don't know. I don't recall seeing that footage produced by the defense. It doesn't mean that they don't have it, but I'm not sure, you know, I'm not sure what the status is on whether or not they have that footage. But she could have looked at that footage and could testify to what she observed. She probably also, you know, could, if she was outside walking her dog or something during this whole process of Karen's car being towed, you know, she potentially could have observed things. So I think that there are going to be a lot of witnesses who are called at this second trial who will be very supportive in nature to people like, you know, Nicholas Barros, who I think they will probably cross-examine now. And another witness that would be a part of that whole part in the timeline for the defense's purposes would be the tow truck driver. You know, the tow truck driver is a witness who the defense can call and immediately dispel all of the key cycle nonsense that the Commonwealth was putting forth, because in the key cycles, they, as you may have noticed, they were missing a column of data that was the time and date stamps, which are the standard is that they're included in Toyota TechStream data. It's odd that they were removed in the Commonwealth's tables, but the one thing that is included in that vehicle data that the Commonwealth didn't remove from those tables is the odometer reading. And tow truck drivers, I mean, that's pretty much something that they have to do every time that they tow a car, is they have to write down the odometer reading on that car, you know, prior to taking it into their custody, putting on their tow truck. That is an immediate way for the defense to dispel the Commonwealth's whole narrative about the key cycles, because it's, you know, it's a way of identifying which key cycle is which. And so I think that's probably another witness they'll call, in addition to cross-examining Barros. And but yeah, I mean, you know, there's also risk in questioning Nicholas Barros, because what if he says, you know, he said there was only a piece missing from the taillight, but what if that, you know, I mean, what could that could transform into something that's worse for the defense if they
well, how does a piece become 45?
Well,
so
that's a good question.
The picture is incongruent with what he stated on the stand. The problem is I don't think the prosecution's going to call him, which means he would be a defense witness, and then he would be cross-examined. So it would be, and I think Hank would try to rip him apart. With the other person you mentioned, the tow truck driver, unless he's subpoenaed, he doesn't have to testify. And the state's not going to call him.
Right? Yes, that's correct. And I had seen a comment come across the screen about the tow truck driver, and I know Olivia was mentioning it. From my experience, from days of old when I first was starting to practice, and I was doing a bunch of different types of law, trying to figure out where I felt warm and cozy. And I did a lot of automobile work, and I think Melanie Little has or had as well in her past. And with tow trucks, there's always camera, there's always pictures, even just for insurance purposes. This is what the vehicle looked like at the time of the accident. And when tow truck driver took custody of it, I bet you there's even now video pieces to that. I mean, I had rented a car in, I think I was in Dallas, Fort Worth this past fall. And I rented a car, and they give you the keys, they go to the car, and then they scan it with their phones now and say, this is what the car looks like. And when I dropped it off, they did it again with their phones. And believe it or not, I got like a little ding, which I deny causing that ding. That car was parked in valet the whole time. And I have no knowledge that the
Olivia can represent Nan if this goes to trial. Okay, Olivia?
But they fought me, and I mean the amount of pictures and images that came on the rental car correspondence to me saying you dinged our car and what are you going to do about it? And I'm saying, geez, are they the CIA? Which I have to say, Olivia, you absolutely need to go sit with Karen's defense team.
I thought you were going to say I need to join the CIA.
Well,
yes,
you have to. I'm not convinced you're not already employed.
Yeah.
You'll never admit it.
I sent a long email to David Unetti's office because I had emailed them about someone from Canton who approached me about a certain angle of this case, somebody that they knew about. And Unetti called me like almost right away. I didn't even see it until a couple days. It was when I was moving from Georgia to Colorado, but I called him back and spoke with him. And then he spoke with this witness in Canton. So I made a Word document of things that Olivia stated last time she was on the show, and then went ahead and sent it off to Unetti. So yeah, if they're not talking to her, I mean, I would assume they are. And if they are, she's not going to tell us that they are. So I hope that they are. I want to get some questions, and I'm not one to do 2-hour shows, and we're about 10 minutes short of that. But I want to get some questions from the chat in. So let's make these quick hitters, lightning round, if you will. Here is Amy, Positive Pathways, and maybe Bea can read. Let's let Nan read it. Maybe maybe she has an accent.
Let me
for us.
put on Nan. My school teacher glasses. Okay. Can the Commonwealth change the reverse 24 mile per hour and hit him theory? Can they change to he was bumped and fell and hit his head? That seemed to be what Brennan was saying to Dr. Russell. They can. So you can't change facts, and I'm still not convinced that all the facts are accurate, but you can change strategy. You can change experts too. I'm keeping these quick for DJ and Bea. So yep, the answer is yes.
There you go. See, I didn't know that. So that's great. I thought the answer would have been no. So we learned something. All right, I'll do this.
Doing it, DJ. I don't think they should do it because Karen's team's going to hop on that, but they can.
Yep. This one we'll do in Ken's mom's voice. Are there witnesses ever allowed called in these motion hearings, even potentially the motion to dismiss? So these motion hearings, can they call witnesses in these?
Are these coming to both of us?
Yeah, sure. Yeah, Olivia, if you'd like to answer, go for it, man.
I don't see Olivia anymore.
I don't see Olivia either.
Oh, all right.
Olivia, are you there?
Oh, there
what happened to you, my dear? Welcome back. Okay.
Hello?
Yes, you're back. You're back on your cell phone?
Sorry, I was messaging you on Twitter and in the chat feverishly because StreamYard booted me out, but
she got yeeted, DJ.
Sorry about that.
How dare you to Olivia Lambo?
Bad
okay, so
I'll hit this question just because she had gotten yeeted, but the next one can be all hers. We're doing quick hits with this. Are witnesses ever allowed to be called in motion hearings? The answer to that is that would be extremely uncommon. Only if there was a real side issue. For example, if there tends to be a piece of the motion to dismiss that involves chain of custody, and there needs to be some testimony taken from someone who has relevant knowledge about that, but generally no.
So
Yeah,
yes, it depends, maybe.
Well,
Exactly. The lawyer
Okay.
answer.
Okay.
and to elaborate on that,
Yeah.
actually, so yeah, what Nan is saying is absolutely correct. Like an evidentiary hearing would be an example where you might call like that. Actually, seems like it would probably be appropriate for the whole Sallyport footage chain of custody, because nobody seems to know like what the origin of that is or what the whole story is behind that. But another example actually of where there was an evidentiary hearing scheduled in this case, and that both sides, the court, everybody had agreed to it. It was pre-scheduled, obviously. Was back in. It was scheduled for May. I forget if it was in the early or late May of 2023 hearing, but essentially it was right after the defense had filed their bombshell motions with the Richard Green findings from Gemma Cabe's phone, you know, of the Google search and the different things she deleted. And just to highlight one thing that a lot of people who didn't file the pretrial stuff just don't know is, because I always hear, you know, like attorney Joe Krowski on Court TV saying, oh, well, the defense, you know, they came up with this conspiracy like over a year later and blah, 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 like all this stuff. And what's important to note is that the Commonwealth withheld and didn't turn over to the defense the full phone extractions for Gemma Cabe's phone or for John O'Keefe's phone. So of course they found all these bombshell filings in their April 2023 file, or all these bombshell findings in their April 2023 filings, because they didn't get those phone extractions until February 2nd of 2023. So they promptly filed filings exposing those findings right after they got that evidence.
Yeah.
It's not like they, you know, got the phone extractions a year prior or 5 months prior or anything like that, and they just were trying to cook up some conspiracy theory. Not at all. So anyways, long story short, there was an evidentiary hearing scheduled for that. It was then almost in what looked like it was in concert, the witnesses, Jen McCabe, Brian Albert, at the same time that the Commonwealth filed its opposition to that hearing occurring, even though they had previously agreed to it, the witnesses, Jen and Brian, filed motions to quash the subpoenas, you know, calling them to come in and testify at those evidentiary hearings. And the defense had already flown out their expert witness, Richard Green, for that hearing, paid for his time, paid for his flights and everything. So it's yet another example of, you know, paying to fly experts out for fruitless visits.
Draining draining Karen of her money. Yeah.
So that's an example of a motions hearing where witnesses were being called, and then that just all went to crap. But
yeah, and this one right here, the Rule 22, if a party objects to a ruling or order of the court, he may state the precise legal grounds of his objection. So Valhalla law, apparently, I don't know where Bev gets this. I don't know but Valhalla law seems to say that Rule 22 says that you can state that. I don't know if that's of Massachusetts. Go ahead, ma'am.
No, oh, sorry, DJ.
Yeah,
and even
please.
Andrew Meyer yesterday on Brit Happens, he's a also local attorney up there. He said, no, you put your, I'm not going to conflate, but you put the basis for your objection on the record. So this is very, it grinds against attorneys like me when I see this happen, and I go, you need the basis. And I think we can all agree perhaps that even Lally didn't even know half the time why he was objecting. So
it didn't matter. He just knew that 90% chance she's going to sustain it anyway, or they're going to go to sidebar, and either way, it's going to ruin whatever kind of momentum that the defense that actually had a real skilled lawyers were developing, and that was their goal. You know.
Yeah, and you remove it's just another layer of what, in my perspective, of what seems like a concerted effort to remove transparency in this case, or to, try to, I guess, like handcuff the defense, because stating the grounds for objections, it provides a very necessary context for the public who's following along the trial, for attorneys who are watching the trial, and even for the jury. Because a specific example from the first trial was when Lally was questioning Lucky Lawfren. He kept when you're trying to impeach a witness, you essentially will say, well, didn't you say this in your first interview, or your first, your testimony at this grand jury, or what have you? And what's his name, ADA Lally kept misstating or misquoting what Lucky Lawfren had said in his interview. And the problem with that is that it's a way for Lally, which I think deliberately this was his intended strategy, it's a way for him to basically imply or make this witness look like they're not credible. But each time David Yannetti was objecting to each time Lally misquoted the witness, because of course he knows that he's misquoting the witness. And Bev allowed the questioning to continue. Now, if that context is very necessary, though, I believe, for the jury or for people, because attorneys, they still they'll ask questions that they know are going to get objected to, because they're just trying to put that thought or put that idea, plant that seed in the jurors' heads. Now, whether or not that's you agree with that, whatever, it's a fact that all attorneys do it.
Yeah.
And so removing the context that's provided by stating the grounds for objections, I think, especially in a case like this, is really problematic.
Totally
And
agree.
yeah, of course, all the sidebars being off the record, well, I guess they're still on the record, but the public doesn't get to hear what's being discussed, is another problem.
There's so many. And I don't know if Nan saw earlier that someone put up there. You're probably already aware of this, that they were lunchroom ladies, Bev's
Yes.
mom and Mike Morrissey's mom for 30 years. And then there was the whole thing with the Airbnb that I think the Nagels
Yep.
rented. And so, when they said, for any honest judge would have said, well, you know what? I'll just recuse myself, because I just want to eliminate any, even the inference, that the potential, and give it to another judge, the appearance that maybe. But Bev is not honest, and I can say that because I'm not Mark Betterow. I'm not you. You and brother counsel. Who knows? You could have to make an argument in front of her. I never will.
Well,
So
and I've applied to waive into the Massachusetts bar. If I can get admitted there, I'm definitely going to want to appear before all different types of judges up in Massachusetts. And the term, DJ, is the appearance of impropriety. And
right.
Yeah.
I agree with you. Even if there's a hint of it, most judges really should say, I'm going to avoid that hint of impropriety. And I think she would have done herself a favor had she done that, which leads me to have suspicions.
Well,
she couldn't influence the trial if she did that. She had to be able to continue. In fact, she got herself kicked off the Brian Walsh case so that another judge wouldn't have this, because she wants to be able to influence this case. She's not fooling anybody. We know that she's dishonest. We know she doesn't like Jackson. We know she doesn't like Reed. And I'm wondering, I worked for government for many, many years. I'm wondering if anybody has taken a freaking ethics course. I don't feel like she skipped the day that they taught ethics at law school, which was, I guess, a whole day at the bar of the, your examination there. She's an absolute. Go ahead. I'm sorry.
No, I was going to say, I agree with you. I have questions about her. I do.
And the problem is, going off of what Nan said, the standard for recusal is the mere appearance of impropriety to the mere appearance of impropriety to a disinterested member of the public. And so it doesn't matter whether or not the the things that, if anybody wants to see a lot more detail on this subject, you can go back to the defense's motion requesting Judge Beverly Cannoni recuse herself. But they go through a lot of different things that are mentioned that suggest impropriety or a bias or what have you. And it doesn't have to be proven, or it doesn't have to be true or factual. It's the mere appearance of it. So she seemed like, when she went and took her 10-minute recess to review that motion, where one of the first motions she ruled from the bench on
was hers.
Personally, I personally was watching that in real time, that hearing, and I felt that her ruling and her explanation to that was very emotionally driven. And of course, that's not how the law is supposed to be. It's not supposed to be based on feelings. It's supposed to be based on the law and facts and principles. So
free of pride or prejudice.
Yeah, exactly.
And she, sorry to interrupt you, but in my jurisdictions where I'm licensed, judges have to actually, when challenged or not, they have to put on the record what the basis for the allegation of conflict are. So, for example, she should have said, and I don't think she did, from what I understand happened, she should have said, yes, you have challenged me. Yes, it is true that my brother or whatever the relationship is, this person previously represented that person within my family.
That's another one.
There's a connection there.
It's her brother, John Prescott Jr. was Chris Albert's attorney for when he got into the 1994 hit and run accident where he killed a man, Peter Berger, and injured oh gosh, I'm forgetting her name, the passenger's name, and only served 6 months of prison time. His attorney was Judge Beverly Cannoni's brother. So, but they actually didn't reference that in their recusal motion, which I think is, I'm like wondering if they didn't know that information yet at that time or not. But yeah, I mean, that's a very compelling reason alone on it.
And then
on its own,
the issue of whatever it is, the lunch lady thing, or however that worked. As you see, I only hear enough for me to say, there's a problem. I rely on people like Olivia and Brother Counsel and others to kind of get in the minutia. But the judges in my jurisdiction have to say, these are the allegations being raised, or these are the connections which I have to disclose. I can't tell you how many times I go before judges and they say, I own stock in United Healthcare, or I own stock in Horizon Blue Cross Blue Shield. I don't personally have X, Y, or Z. I don't feel it would cloud my judgment. That's not happening here. In fact, my understanding was she kind of took her little break, came back, was emotionally charged, and kind of said, no, I don't know anything about this or that. I mean, there is a reason why she is referred to as Auntie Deb and you have so many different handles about this, and Auntie Deb Side Bar and Grill, and Auntie Deb this and Auntie Deb that. It's there, and it's the appearance to a reasonable person, or whatever the verbiage is. So there is, as I said on another stream, there's a cornucopia of issues in this case which make it really interesting, but also really disheartening to follow it.
Very disheartening.
Yeah.
So I want to throw this out there as our last thing, because this came from Valhalla Law, Massachusetts attorney, and then we're going to do our cabby goodbyes and say thank you to our guests. But she says, part of the reason they upgraded the charges to murder is so the case would be transferred to Superior Court, where Bev sits. Oof. She couldn't take the case if it stayed in district court. Valhalla Law throws nuggets like this in all the time. So I just want to let you guys free reign on that, but make it quick because we got to close the show.
I got you. I think that's unbelievable, and I'm having a light bulb moment. So the conspiracy could be even deeper than I've fully appreciated it. Wow.
The lunchroom mom thing, the whole thing where
I mean-
Mike Morrissey's mom and Bev's mom were friends. That's something you know. You know when your mom works with another lady for 30 years and develops a relationship. You know that.
Even more. There's even more connecting Michael Morrissey and
Connective
Judge Beverly
tissue.
Cannoni. I was gonna say connective tissue. That's so funny you were thinking that. I was like, what is that thing? That biological? Yeah, connective tissue. I've actually received I get a lot of DMs, and I apologize to if I don't respond promptly to everybody, but I've gotten a number of DMs about this particular subject, and yeah, maybe I might do a post on that at some point. But yeah, there's more connective tissue connecting them. I'd be curious to see what Michael Morrissey's iCloud communications look like, and if
with
he
Judge
ever
Bev?
reached out to Bev.
100%.
Yeah, that would be interesting.
100%.
Because those are all impounded. They've been requested for discovery, but they're impounded, so we wouldn't know at this point, if there is anything or not. But it's an interesting point what Valhalla law is. Sorry if I'm mispronouncing
Valhalla law,
that.
yeah.
Okay. I mean, I don't know. Of course, it's speculative. I don't know, but there's a lot of questions I have about everything, why the charges were upgraded. I mean, there's just this incredible article that I found. I did a post on this, where I believe it was like Law and Crime and like a local news outlet they spoke to DA Michael Morrissey right after they had indicted Karen Reed. So after they'd upgraded her charges and formally, had her arraignment for those upgraded charges. And, he's being interviewed about the case or the investigation. And he says something to the effect of how they still didn't know, they couldn't discern whether John O'Keefe had died from like a slip and fall or what exactly was the cause of his death, but yeah, we're moving forward anyway. And I was like, are you how is this real life? Like I find these articles where he's being interviewed by these outlets. It's like he was saying on the record back in this summer of 2022 that they still didn't know, they couldn't differentiate between apparently murder and an accidental slip and fall. And I mean, it's just like another article I found from Michael Morrissey from last year that I did a post on, where he was interviewed by a local outlet and was recorded saying that actually I think this may have been after the first trial, but he was commenting on the jury, like the jury got it wrong or something like that, that the jury doesn't understand, or I can't remember exactly what it said, but I mean, just wild things to be saying on the record like that when you've criminally charged someone.
Yeah, I mean, one of the things, and I'm looking next, and basically I'm saying this on air so that all the other shows can go and try and get one, but I'm going to try to get a criminologist on, because I don't understand the mindset. Like for me, and by the way, I think I might have wrote that wrong. It's callingallbeings1 at Gmail. And the reason I put that on there is because we're going to do a member roundtable for all y'all that are members. And so that way you can come on air and you could do what you see the lawyers doing right here. Is we're going to have a roundtable. We've done one already, but we want to do another one. So if you want to be on a Calling All Beings roundtable, just email me at callingallbeings1 at gmail.com, and I will get you on the roundtable. Simple as that. So, yeah, I mean, what can I do for members? Oh, I know what you do. I'll put you on air. So easy. Come on air and talk to us. So,
and it's not intimidating. It feels like a Zoom call. So if you've done Zoom calls from working from home,
exactly.
it's really simple.
It's not a problem if you're smart like Beatrice.
Before
thing,
you
yes,
wrap
ma'am.
up your show, DJ
Yes,
and
ma'am.
Bea, I did while we were talking about lunch ladies and corruption.
Yes,
I thought I'd give you a little fun fact.
please.
My lunch lady in high school was James Gandolfini's mother, Tony
Whoa!
Soprano's mother. So, a little
Wow.
homage to the Sopranos. But anyway, I figured I'd leave you with a fun fact.
Thank you. I dig that. Is he from Jersey originally?
Yes, and he was actually from my hometown of Park Ridge. But his mother was a lunch lady at a private college preparatory school I went to several towns away.
And
Well,
you
I
and I
can
are
give
from close area. I'm from Peekskill, New York, so I'm not
Oh,
just
nice.
up the Hudson River, not far. Yeah.
Isn't that
Go
where
ahead, I'm
the
sorry, Olivia.
facts of life are supposed to be
Yes.
said?
Yeah.
Gen
Judy
X,
and Natalie. Yeah.
take the good, you take the bad. Anyway, sorry.
Oh, we should have a dance off like we did when Nurse Kim was here.
Well,
I'm
We were all
in.
dancing.
I saw that episode, and the next time you have one, I'm in.
You're in? Okay, we'll do that
We will
when
do
we
the-
get Nurse Kim on. We'll get
Yes.
Nurse Kim back and we'll get you back and we'll do this thing. Maybe, but Olivia, I mean, she can't be dancing unless you could be dancing, just nobody's going to see us. So we'd love to have you back.
Shake the camera.
Exactly. Yeah, shake the
Shake the camera so we'll know.
But yeah, and I don't even want to talk about the mindset of these morons because it's something they're like sociopathic in nature. But what I do want to do is thank you so much, Olivia and Nan, for coming on air and just making such a great discussion. We're really honored that you would join us.
Thank you for having me, and it's great to meet you, Olivia, and everybody who's watching. Thanks for all of the feedback. I've been watching it. I try to learn and grow from reading it. So thanks.
You both are amazing, ladies.
Thank you for having me. I really appreciate it. And it was really nice to meet you as well, Nan. And Brother Counsel also is awesome. It was so cool to have him on. I appreciate his coverage and his exceptional knowledge of case law.
Yeah. And his ability to sit across a virtual table from Kevin and KP. God bless.
Mm-hmm.
I mean,
So good.
it's that kind of cool that how he probably doesn't lose his cool in court and he's able to maintain. He probably is just showing the same skills that probably make him a great lawyer. So before I close out, so again, thank you, Olivia. It's an honor to finally have you on air, truly, and along with Nan Gallagher and Brother Counsel. Everybody in the chat, thank you, mods. You guys were awesome. And all the people who just showered love and respect and attention on our guests tonight. Bea and I really do appreciate this. So on behalf of Nan, Olivia, and Bea, this is DJ saying peace out. One love. We'll see you down the road. And as always, we're wondering what's up around.